Question 166. The VA's function is to A. Guarantee loans. B. Insure loans. C. Underwrite loans. D. Endorse loans. Correct answer is A. Guarantee loans. The Department of Veterans Affairs, VA, does not lend money directly. Instead, it guarantees a portion of the loan made by private lenders, banks, credit unions, etc. This guarantee protects the lender from losses if the borrower defaults on the loan. This guarantee allows veterans to obtain home loans with favorable terms, such as no down payment in many cases. Question 167. A buyer who is considering making an offer to purchase a home using an FHA home loan asks his broker to appraise the house in order to verify that the asking price is fair. Although the broker is not a state-certified appraiser, he can A. Appraise the house. B. Appraise the house if certified appraisers charge too high a fee for the buyer to afford. C. Appraise the house as long as he gets a written waiver from the owner. D. Cannot appraise the house but can compose a comparative market analysis. Correct answer is D. Cannot appraise the house but can compose a comparative market analysis. A formal appraisal is a detailed, professional assessment of a property's value by a licensed or certified appraiser. It has specific standards and legal implications. A CMA is a less formal estimate of value, typically prepared by a real estate agent. It's based on comparing similar properties that have recently sold. Brokers are not typically licensed or certified to perform formal appraisals. However, they are qualified to prepare CMAs, which provide valuable information to buyers and sellers about market conditions and property values. FHA loans require an appraisal by an FHA-approved appraiser. A broker's appraisal would not be acceptable to an FHA lender. Question 168. Which of the following elements are not required in a lease with a 6-month term? A. Description of the property. B. Assigned writing. C. Legally competent properties. D. Amount of rent and the method of payment. Correct answer is B. A. Signed writing. The statute of frauds generally requires leases for a term of more than 1 year to be in writing to be enforceable. A 6-month lease falls within the 1-year limit, so it can be oral, though a written lease is always advisable. A lease, whether written or oral, must contain certain essential elements to be valid. A. Description of the property. The property being leased must be clearly identified. C. Legally competent properties. The parties involved must have the legal capacity to enter into a contract. D. The rent amount and payment terms must be agreed upon. Question 169. A plaintiff in a lawsuit is worried that the defendant may sell a property which the court is likely to award to the plaintiff in a judgment. The plaintiff obtains from the court a writ of attachment for the property, which A. Creates an involuntary, specific lien against the property. B. Creates a lien pendens on the property. C. Should be recorded in the county where the property is located. D. Both A and C. Correct answer is D. Both A and C. Writ of attachment is a court order that allows a plaintiff to seize a defendant's property before a final judgment is reached. It's used to ensure that the property will be available to satisfy a potential judgment. A writ of attachment creates a lien, a legal claim, on the specific property in question. It's involuntary because it's imposed by the court, not voluntarily agreed to by the property owner. It's involuntary because it's imposed by the court, not voluntarily agreed to by the property owner. Recording the writ of attachment provides constructive notice to the public that the property is subject to a legal claim. This protects the plaintiff's interest and prevents the defendant from selling the property to an unsuspecting buyer. While both relate to pending lawsuits, a lien pendens is a notice that a lawsuit is pending that may affect title to real property. A writ of attachment is a court order that creates a lien. So they are different legal tools. Therefore, the writ of attachment creates an involuntary, specific lien and should be recorded. Question 170. Permission to build or maintain a structure normally prohibited by a zoning ordinance is called A. A variance. B. Conditional use. C. Zoning at sufferance. D. Non-conforming use. Correct answer is A. A variance. A conditional use is a land use that is permitted within a zoning district, but only under certain conditions. It's not an exception to the zoning, but rather a use allowed with specific stipulations. A non-conforming use is a land use that was legal when it was established, but no longer complies with current zoning regulations. It is a grandfathered-in use, not a permission to build something new that violates zoning. Zoning at sufferance is not a recognized legal term. A variance is an exception to zoning regulations granted by a local government. It allows a property owner to deviate from the strict requirements of a zoning ordinance when compliance would create an undue hardship. Question 171. Most junior loans securing real property are procured from A. S&Ls, B. Credit unions, C. Private lenders, D. Commercial banks. Correct answer is C. Private lenders. Most junior money loans are obtained through private investors with mortgage companies acting as the go-between. Savings and loans and banks mostly make first priority loans, and while credit unions are authorized to make both first and junior loans, they are currently not a major player in either field. Question 172. A contract that states the price and terms is A. Implied, B. Express, C. Executory, D. Cannot be modified. Correct answer is B. Express. A contract can be either express contract or implied. An express contract is one where the terms are explicitly stated, either orally or in writing. This includes the price, terms, and any other agreed-upon conditions. An implied contract is one where the terms are not explicitly stated but are inferred from the actions of the parties. An executory contract is one that has not yet been fully performed by all parties. It describes the state of the contract, not how the terms are stated. Most contracts can be modified if all involved parties agree to the modifications. Question 173. Which of the following facts should a seller's broker disclose when presenting an offer? A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. B. The Department of Real Estate changed its name to the Bureau of Real Estate. C. The prospective buyer is Asian. D. Both A and C. Correct answer is A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. The Department of Real Estate changed its name to the Bureau of Real Estate isn't a material fact that would affect the seller's decision regarding an offer. Disclosing the buyer's race is a violation of fair housing laws. Real estate professionals are prohibited from discriminating based on race, color, religion, national origin, sex, familial status, or disability. A seller's broker has a fiduciary duty to the seller, which includes disclosing all material facts that could affect the seller's decision. Information about a potentially better offer is a material fact that the seller needs to know. Question 174. A home is being shown to a potential buyer where, unfortunately, a person died of AIDS 4 years earlier. The broker showing the home has A. A duty under the California Civil Code to disclose it as a material fact. B. No duty to disclose it, because it happened more than 3 years ago. C. No duty under any circumstances to disclose it. D. None of the above. Correct answer is C. No duty under any circumstances to disclose it. California Civil Code Section 1710.2 specifically addresses the disclosure of deaths on a property. It states that a seller or broker is not required to disclose that an occupant of the property was afflicted with, or died from, AIDS. Furthermore, deaths that happened more than 3 years prior to the sale of the property are not required to be disclosed. The law recognizes the potential for stigma and discrimination associated with AIDS and other similar illnesses. It aims to protect the privacy of those affected and prevent discrimination against properties where such events occurred. Therefore, the broker has no duty to disclose the death, regardless of when it occurred, if it was due to AIDS. However, in response to a direct question about it, a seller's agent may not intentionally misrepresent the facts. An agent can simply respond that discussing such information is an invasion of privacy. Question 175. Agency is referred to as the relationship between the agent and his principal. All of the following statements are correct about agency, except, an agency relationship is based on the principal's consent that the agent will act on their behalf, and the agent's consent to do so. While compensation is common, it's not essential for creating an agency relationship. Agency can be created through a formal, written or oral agreement. Agency can also be created through the actions and conduct of the parties, even without a formal agreement.